Darshan is holding.
ಅಲ್ಲ ಡಿ ಬಾಸ್ಗೆ ಎಲ್ಲ ಸಹಾಯ ಮಾಡ್ತಾರೆ.
I guess that is the word that is used.
My lord, this court, my lord, this one, my lord, is in 2023.
Yes, sir. This is a piecemeal judgment.
Yes, my lord. My lord, this court while dealing with an application filed under section 311.
Para 11. Same. Yes.
My lord, this court in another petition, while dealing with an application filed under section 311 seeking recall of the witnesses who were examined and discharged. Well, a second application came to be filed on the same ground, which came to be entertained by the High Courts under section 482. But on the day when I made the first application invoking the jurisdiction of the High Court under section 482, I had more than one ground that was available to me on the very day itself. But I am before the High Court under section 482, only urging one ground. The rest of the grounds, my lord, I don't urge. My petition got dismissed. But again, I would make an application invoking the second ground that was available. If that ground was also available on the first day when I made the first petition, second petition is not maintainable. ತೋರಿಸ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಲಾಯರ್ ಪಕ್ಕದಲ್ಲಿ ಕುರ್ಚಿ ಹಾಕೊಂಡು ಕೂತಿರೋದನ್ನ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ. But I am not building castles in here. I stand by that.
No, it's obvious. You need not even say. You will obviously be there because it is recorded at the stage of trial.
ಅಲ್ಲ ಇದೆಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್
ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಾಗ್ಲೂ ಅಲ್ಲಿ ಲಾಯರ್ ಇದ್ರು.
ಇದೇ ಲಾಯರೇ. The lawyer who was representing this first accused during the trial of this case till the date of his application becomes the lawyer for him to make the application under section 306, and it is the very same lawyer who files the wakalatnama at a point of time when his statement under 164 came to be recorded by the magistrate. Signature ಹಾಕ್ಬಿಡ್ತಾರೆ ಅವರು. Number one, he could not have recorded it at all. I mean, directed it at all. Number two, he has also not recorded as mandated under law his statement under 164. Number three, if everything is in order, he could not have placed reliance on the statement said to have been recorded under 164 for the purpose of granting pardon to the accused.
Now, whatever he has deposed under 164, if that was the part of the application under 306, there should not have been any problem.
No, even then 164 can't be done.
No, that's all right. ನಾನು ಹೇಳ್ತಿರೋದು.
Yes.
ಈಗ 164 ಅಲ್ಲಿ ಏನೇನು ಹೇಳಿದ್ದಾರೆ ಅದು 306 ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ
that would have been the ground. That would have been the ground. I am a party. Ultimately, I am the man who gets aggrieved. I am as much a party to the case during trial as the prosecution is. The trial court ought to have given me notice. Look here, so and so is before the court. What have you got to say? I am not a party to this order. I am not a party to the application. I am not a party to the statement of objections. Everything is done behind my back. And the learned judge would say, it is not in dispute. Idರಲ್ಲಿ, he was an accused, arrested, the notice of the crime came to be registered. ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದಿಲ್ಲ 164 ಇಲ್ಲ ಅವಾಗ. If at all there is any statement, the statement would be under section 27.
Correct.
That statement may not can't be adverted to or looked into for any other purpose other than for the purpose that is enumerated in section 27. ಅದರಲ್ಲಿ ಇದು ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಇವ್ರಿಗೆ?
No,
ಇವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದಾರಲ್ಲ.
entire order is based upon 164.
164 entire order.
Yes. ಅಲ್ಲ, because paragraph 14,
Yes, madam.
para 14 ಅಲ್ಲಿ one paragraph.
ಹೌದು.
ಮಿಕ್ಕಿದೆಲ್ಲ that is extraction.
ಅಷ್ಟೇ. When law could not and did not, the court could not have closed the jurisdiction upon the magistrate to record his statement. That is illegal. It is an illegal law. He could not have. If my lord were to eschew, while accepting my submissions, that the magistrate had no jurisdiction to have recorded the statement under 164, but when the learned trial judge has placed reliance only on the 164 statement, this order has got to go.
ಅಲ್ಲೇನಿಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಅಲ್ಲ ಅಲ್ಲಿದೆ
164 ಪರ್ಮಿಷನ್
ಅಲ್ಲ, ಫಸ್ಟ್ ಪಾರ್ಡನ್ ಆಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅದು ಗೊತ್ತು.
ಇದರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ
ಅದು ಗೊತ್ತು.
ಆರ್ಡರ್ ಬೇಕಾದ್ರೆ ಓದ್ತೀನಿ ಅದನ್ನ. He says, go there, give your statement, I will verify whether what you have said or not.
That is why, see, the court has cautiously done it. It does not record the statement itself. Otherwise, it would have become trial during the course of trial. Before granting of pardon, that cannot be done. So, record the statement, take that statement, and continue the trial.
ಅದೇ ಆಯ್ತು. ಇವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಬ ಹೋಗುತ್ತಂದ್ರಲ್ಲ, ಅವ್ರಿಗೆ ಏನ್ ಅಧಿಕಾರ ಇದೆ ಮಾಡೋದಕ್ಕೆ? ಏನೋ ಪ್ರಶ್ನೆ ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ. A plain reading of,
Unless he
unless my lord were to interpret,
Polishes it.
my lord were to interpret, my lord, section 164, ultimately we have got to carry what my lord is going to pronounce in this case on our shoulders. Unless and until my lord interprets, no, despite the fact that the famous of law in their wisdom have said that it is only during investigation, at any rate, not subsequent to the commencement of inquiry trial, my lord, that becomes the law. But they would dismiss
second
it.
petition is maintainable only on changed circumstances.
In this case,
You cannot see what the Supreme Court says in that is you cannot urge grounds in piecemeal. You should come out whole hog. Yes.
but in paragraph 4, the learned judge of this honorable court would say, learned trial judge on consideration of the material on record has recorded a finding that the petitioner had filed an identical application on an earlier occasion and the same was rejected and so on and so. Without challenging the said order, the petitioner has filed this same application again. Learned trial judge has also recorded that one of the grounds urged in the application is that the previous advocate was not aware of the documents which were in possession of the petitioner. He has recorded that the petitioner had filed an identical application on an earlier point of time and the same was rejected and that the said order has attained finality. It is not in dispute that a similar application was filed earlier and the same stood rejected. The said order which attained finality was not challenged. Therefore, it came to be dismissed.
Yes, Sandesh sir. Yeah,
The other day,
sir.
the learned special public prosecutor raised an objection with regard to the maintainability of our petition.
Why?
Locus.
Locus.
They were on
He
the
has
outskirts
raised
of
the
locus.
objection.
Co-accused cannot challenge it with what they were trying to counter.
Have I said so in the other petition?
No, my lords. They are relying on one of the Supreme Court rulings where, my lords, they pointed out locus so far as co-accused, but immediately the next line says court has suo motu powers.
Your lordship noted that
So
also.
revisional powers and inherent
motu.
powers court has. We are the ones who are bringing it to the notice of the court. My lords.
Well, no one has a right of revision under section 397. The court may, did not shall.
My lords, I'll keep it very brief.
And
Extensive,
inherent
it's been
powers.
argued. My lords, first of all.
I only want that point.
No, this was not available earlier. No, this was
What is the date, sir?
date either lilla. Not I can
It is
find
not
out on
date.
what date. Not it was this was handed over not to the IU.
True, sir. But what is the date of this?
Not
Only
date.
to say that this was available to the previous application also. Now, if
It was
it is
not.
not, if it is not, then what is the date of this?
No, that I cannot find out the date. Not and this was not available. This letter was not available because there is absolutely no reference not to this letter. Not even in my earlier report of the IO or not the objections not by the prosecution or in the order. There is absolutely no reference not to this
All right.
letter. But
Fine.
this letter, the accused number one not to disclose, not completely, not what the facts not within his knowledge. Or if for any reason, but this honorable court were to come to conclusion.
One simple question. If the accused had already penned this down and submitted to the investigating officer,
Please.
what was the impediment to pen everything in the application by the same person?
Not 3 or 6 doesn't say that everything
No,
must be stated.
not
in the
everything,
application.
Allah. What are the he has to say, these are the things
Not-
that I
kindly
have
look
to,
at- no,
I
kindly have
am
look
wanting to depose in favor of the
Kindly
prosecution.
have a look at page 92 is application.